Welcome to today's program titled The State of DEI. At this time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, later in the presentation, we will read the CLE attendance verification code. Please write this code down, as it will not be reread and it is required on the CLE credit request form. During the program, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Annette Timon. Annette, please go ahead.
Thank you very much, and welcome everyone to this webinar. We are thrilled to kick off our DE&I webinar series. For those that may not know me, my name is Annette Timon. I chair our People Analytics Practice Group here at Seyfarth Shaw, and I am thrilled to be joined by Christy Kiley, who is a partner in our Washington, D.C. office. Both of us have been doing an incredible amount of work in the DE&I space, along with many others at the firm. And we just really thought it was important to continue pushing out information and content based on the shifting changes that we're seeing in the DEI landscape in particular. And I can just tell you that the interest is astounding. We have nearly 1,000 folks that have signed on for this presentation alone, and it just tells you how much interest there is with the changes. So let's go ahead and flip to the next slide, and we'll give you kind of a headline, a roadmap of where we're headed. We just finished up the introductions, and I'm going to talk about our series and what's coming up ahead. We're also going to talk about recent litigation that's going to impact DEIB programs from our perspective. We'll talk about current challenges in the DEI space, some practical advice, and we'll close it up with a conclusion and where we're headed. On the next slide, you'll see we have a few sessions lined up. We are doing this as micro sessions or micro webinars, half an hour topics, hopefully taking a small chunk of time to talk about issues that are critical and important, and we're going to try and do deeper dives on each one of these. So today is more of a state of the DEI overview, but you'll see that the very next series that we have, and we're trying to space these out about 2 to 3 weeks spread apart so that we can get through a nice chunk of different topics. So we want to talk about the importance of auditing or assessments of your DEIB programs, exploring and mitigating risks with specific initiatives that are out there. We'll talk about exploring voluntary affirmative action and manifest imbalance. We're getting a lot more questions about that these days. We're going to talk about artificial intelligence and how you might use that to support your DEIB efforts, leveraging your employee resource groups. We're also getting a lot of questions these days about faith-based employee resource groups, so we'll have some content there. And then we also want to talk about global approaches on DEIB, self-identification, and related issues. So with that, let me kick off I think an important issue that we've seen come up, which is the Muldrow versus City of St. Louis decision. That is a Supreme Court case. On the next slide, we'll see that. The plaintiff was a sergeant, right? And she had been worked for many years. She was essentially a plainclothes officer, worked as part of the head of the gun crimes unit, worked very closely with the FBI, had her own car, but she was transferred. A new manager came in and decided to move her out of her position and move her into a different role. And once her role was changed, she had to give up her car. She had to give up, she had to start wearing kind of police, an actual uniform. She went from kind of being in, working with the FBI to doing day-to-day patrol work, right? Overseeing the reports that were done by police officers. She also had to do some reports or her, take patrol duty herself. Her work schedule was changed a bit. However, nothing about her actual job from the perspective of her compensation changed, and she didn't really allege that she had been significantly disadvantaged. She did, however, contend that her transfer was motivated by sex discrimination. She brought her case under Title VII in the Eastern District of Missouri. The district court granted summary judgment to the city of St. Louis, so against Ms. Muldrow, and the Eighth Circuit affirmed, contending that she basically didn't bring up any issues of material fact and that she could not show that she suffered a materially significant disadvantage. Less than a month ago, the Supreme Court opinion came out. It was a unanimous decision. The majority opinion was written by Justice Kagan, and we see some concurring opinions, which I'll talk about, especially Justice Kavanaugh's concurring opinion, but Justices Thomas and Alito also wrote concurring opinions. And essentially, the Supreme Court's unanimous conclusion or opinion was that Title VII requires a plaintiff to show some harm for a forced transfer, but there was an express rejection of any sort of adjective that you would put in front of that harm that suggested that the harm had to be significant or material or in some way a heightened standard be applied. And those were opinions that the First, Second, Fourth, Seventh, Eighth, and 10th Circuit had all ruled on with regard to transfer cases or other terms and conditions of employment. So that decision was vacated and remanded for further decisions consistent with the court. And on the next slide, we'll see that Justice Kavanaugh's decision in particular, concurring opinion, really does foreshadow that the harm component can go beyond, number one, transfer decisions, but also with regard to what we're talking about today in the DEI program. I just included a few of the parameters that he identified for a showing. He thought it could be, an easy way to demonstrate harm based on issues that are tied to transfer specifically, but there are obviously implications for DE&I program. And in particular, to the extent there is some harm that's shown from career prospects, professional relationships, networking opportunities, prestigious programs that you might have, those are all, at least in Justice Kavanaugh's view, issues that are likely to be able to be demonstrated as showing some harm to an individual. So on the next slide, what does this mean, right? We're talking about DEI programs. Well, we certainly do think that this lowers the bar likely for adverse employment actions. I shouldn't say likely. It absolutely lowers the bar. The Supreme Court made that clear. It lowers the bar to the extent, at least as in terms of how other courts had applied it. It certainly potentially increases the scope of activity that's protected by Title VII. And the reason why it's important when we're thinking about diversity inclusion programs is that sometimes programs would come up and we would have this whole analysis and trying to assess, well, what is the harm to an individual? Does it take away their money? Does it create a demotion? What is the actual harm? And a lot of the DE&I programs really didn't fall squarely into that particular framework. So I mentioned all of those circuit court decisions that found that there was this higher standard that applied. And so oftentimes when we were assessing or evaluating DEIB programs in particular, there was at least a perception that there was a lower level of risk associated with those. we've already seen anti-DEI groups that are using the Muldrow decision to support some of their allegations just a few days after the decision. One of the cases, one of the stakeholders that is attacking many employer DEI programs listed Muldrow in the second kind of framework as, paragraph alleging, hey, we've got a standard here and a finding from the Supreme Court that says you don't have to show material disadvantage. The other thing is, to the extent anyone thinks that this might be limited to transfer decisions only, I can share that, the EEOC has already filed 2 amicus briefs in other contexts, one in the race context, one in the ADA case, and seeking to expand the decision and basically saying that, the same terms or the same words in Title VII are found in ADA cases, so there's applicability there. So we are expecting that this is going to have much broader connotations. The Third Circuit asked litigants in one of their cases to talk about the impact, potential impact of Muldrow. So in less than a month, there has been a lot of activity, and we do believe that there's going to be an expansion of the efforts, and in particular, how it would impact DEIB programs. So we have been watching this particular case for quite some time because of the potential implications here. So with that, I'm going to turn it over to Christy to pick up on current challenges.
Great, thanks, Annette. And we are going to circle back to Muldrow when we talk about our predictions for future challenges, because as you just said, it certainly is changing the landscape. So if we can go ahead and head into the next section here. What we'd like to do is give you an overview of kind of where we see things today and in the near future. There's no question that 2024 is going to be a very important year in the DEI space. I'm actually sort of astounded that we're rounding on a year already since the fair admissions decisions last summer. It seems both much longer ago than that and not as long, depending on the day. But, there has been a lot of movement in this space. In the months immediately after the decision, it sort of took time for the dust to settle, I would say, in the second half of 2023. And it obviously takes time for litigation and cases to percolate up through the court system. And now that we're in 2024, we are squarely seeing that, as Annette just alluded to. So there will be an increase in litigation, an increase in the types of challenges that are raised. And we're going to go into some of those specifics in the next slide here. So there's several dozen cases that are active right now at some sort of decision point or have just been recently decided, specifically targeting DEI programs since fair admissions. So again, there is activity out there. And what's interesting is they're brought by a number of different kinds of plaintiffs. Employees and former employees, of course, are one of those, but also these conservative advocacy groups, think tanks, and also shareholders and other stakeholders. And we've listed here, I'm not going to go through all these because we're going to talk about them in a little more detail here in a moment, but these are the types of allegations that we're seeing. And in particular, claims that a decision action was motivated by a company's DEI program and a desire to increase the representation of one demographic group to the exclusion of another. That has been a very common theme in the litigation. So allegations by white males, for instance, that they were not promoted because the company wanted to advance minorities, that they were let go in favor of a less qualified female. Those are the types of allegations that we're seeing pretty consistently across claims. Let's go to the next slide and we'll dive into some of the specifics in a little bit more detail. So this is where we've broken down kind of what we've already seen in the recent years and where we think, especially in light of Muldrow, things may be going. So the items in green are ones where we've already seen very specific legal challenges, either in the courts or just through our clients dealing with issues. DEI goals, of course, is a very big one because goals are easy to latch onto. When they're front facing, they're public and easy to identify. So things like saying we want gender parity in leadership by 2025, for instance, things like that. We're still seeing challenges related to goals, but that's not new. I did just want to note this is not brand new since fair admissions. Annette and I both do a lot of work in the government contracting OFCCP space with affirmative action. And back in 2020, then director of the OFCCP, Craig Lean, sent letters to 2 large companies challenging them on their diversity pledges when they had publicly stated they wanted to double minority leadership by 2025. And so the OFCCP government agency challenged these companies and said, how can you do that consistent with non-discrimination principles? How can you increase diversity without running afoul of that? And so the question was raised back in 2020 about all of this. And in that instance, the companies provided information to the OFCCP's satisfaction and answered the question, and the matter moved on. But this is a theme that has been going for several years now, and I think that's likely to continue throughout 2024 and perhaps beyond. I would note that goals themselves are not unlawful. It's the implementation that gets tricky. So we could do a whole separate webinar on that. It's especially when things are tied to compensation decisions, when executives get, a higher LTI percentage, for instance, or a larger bonus for increasing diversity. Seeing claims based on that, because there you have an ostensible tie between specific employment decisions, who to hire, who to promote, who to retain, and DEI goals, which arguably, according to detractors, are not neutral, right, and non-discriminatory. So when you tie compensation and start to incentivize decision makers, you have to spend a lot of care and attention on the details of those programs. As ERGs, Annette mentioned ERGs, we're getting increasing questions about those. I don't believe there's litigation on that to my knowledge, but certainly common themes of questions. Diverse slates. Diverse slates can mean 100 different things depending on what a particular company is trying to do, but they are very much subject to challenge, and they're sort of one of those lightning rod terms that tend to draw attention, much as DEI goals or diversity pledges do. So very sort of front and center in terms of what our clients have been dealing with. And then another one, of course, is the internships and fellowships. And the most recent example of this was 2 law firms who were sued over their diversity fellowship positions, paid positions. And they were sued over these diversity components, arguing that non-minorities were being excluded from those positions. And both law firms did, either as a result of that litigation or around the same time of that litigation, end up changing their diversity criteria for those as a result. So we expect to see some additional challenges in that area as well. Those are the ones that have really been the core of DEI challenges to date. The ones in red are where we see things pivoting potentially in light of Muldrow. We have been getting questions about things like mentoring programs, leadership development, sponsoring, other forms of internal development, where employees don't get a tangible job benefit by way of a promotion or a pay raise, but there's unquestionably intangible benefits, right? Like, unfortunately, the things Justice Kavanaugh referenced in his concurrence, like networking, like connections, like knowledge, improved skills. So, these groups are in fact pivoting and using Muldrow to start to go after some areas that previously had been in much more of a gray spot from a DEI perspective. So those are going to be a focus this year. And scholarships and diversity programs are 2 others. The vendor diversity, I should say, actually is in the existing category. I missed that one, but there are existing challenges out there to vendor diversity programs. Even though it's not employment per se, those challenges are brought under Section 1981 of the Civil Rights Act of 1991 on the theory that there can be no race discrimination in any form of contracting. And so supplier diversity, the theory goes, if you are awarding contracts to vendors based on diversity, you could be running afoul of 1981 is the argument they make. And that's pivoting now into these other areas like scholarships, where there's a financial benefit. It's not employment per se, but a financial benefit, money towards school that may be based on diversity criteria. So that's a listing of some of the core areas. If we go on to the next slide, we're going to talk now about what we hope is some useful practical advice for all of you, because we could sit here and talk about DEI and wax poetic all day long, but what's really useful to you is knowing what to do about some of these issues that continue to be very difficult for employers. Let's go ahead and go to the next slide. It's still very much a question for most companies if their DEI programs are appropriately walking that line. There is a challenging line to walk with legality under Title VII, ones that can be permissibly done in the DEI space, lots and lots, but the devil is in the details, as they say. And so companies are still very interested in knowing if their particular DEI initiatives are subject to challenge, if they're likely to be challenged as a practical matter based on how they're communicated or what their particulars are, and then what, if anything, they do about it if they do want to make some sort of an adjustment. So that continues to be a huge issue, which is why we are following this micro webinar series with one about doing DEI audits, because that's really what those are about, is getting into sort of the nitty-gritty of DEI programs, looking at the specific mechanics of how things operate, what they're intended to do, and how they are reconciled with current, existing, and ever-changing law in this space. So that continues to be important. If you have not yet done a DEI audit of some sort, whether it's of a particular program that maybe is a spotlight or has had a complaint, or the overall comprehensive DEI scheme of your organization, you really want to take the chance to do that. As a general rule, when you're looking at things, the closer you get to an employment decision, or in light of Muldrow, an employment benefit of some kind, the closer you get between an employment benefit and a protected diversity trait, like race, like gender, like disability, etc., the more problematic it's going to be and the more thoughtful you need to be about the details of how it's done. The more you can separate a specific benefit or action of some kind from those DEI considerations, the lower on the risk spectrum it's generally going to be. Okay. The next slide actually talks a bit more about DEI audits. I think I've covered a fair amount of this already. Yeah, I like the analogy of looking under the hood and kicking the tires, right? That's basically what you're doing. Getting behind sort of the generalized statements about DEI or the core values and looking at the action items and what a company is actually doing. So that's just a great tool that employers have at their disposal. Let's go to the next slide. Okay. Another question we get is, well, what is everybody else doing? Are we following the trends? Are we out there in front of everybody? Where does our company fall, on the spectrum of DEI? And very fair question. I know that this sort of joke canned lawyer response is, it depends, but it really does kind of depend what each company wants to do in this space. They're unique based on their prioritization of DEI, their journey, how far along they are towards things like transparency. Every company really does have its unique position, so it's hard to generalize. But I would say, and I will say very comfortably and happily, we are not seeing companies backing away from DEI efforts, and we have not seen that in to any significant degree since the fair admissions cases. What we have seen is companies who remain very committed to DEI and simply want to make sure that they are being thoughtful and strategic and protecting their organization and proceeding, but no withdrawal from the concept of DEI, which I personally find really reassuring. It is interesting if you go out there and you Google, DEI, there are news articles on both points of view. Some sort of herald like the end of DEI, the sky is falling, it's all over. Others say everything is absolutely unchanged. I would just caution you to take all of those reports with a grain of salt, because they're just points of view like anything else. And again, what we are seeing in reality is that employers are staying true to their DEI principles, and some have even doubled down in response to the opinion because they want to say, hey, we're showing we're still committed. So let's go on. I have a couple other quick things before I turn it over to Annette for the conclusion. I did want to talk about DEI training. So there have been a few lawsuits based on DEI training and under sort of interesting theories. One individual tried to sue on DEI training under a hostile work environment theory, where he claimed he was being harassed by having to sit through diversity training. Others can claim it goes against their religion in some fashion. So there's various legal theories. To date, there has not been an adverse finding on DEI training. You may recall President Trump issued an executive order 13950, I believe it was, in 2020, that prohibited certain types of DEI training for government employees and contractors. I would just note that there is absolutely nothing wrong with DEI training that is focused on the values and benefits of diversity, on inclusiveness, on acceptance, on open-mindedness, on the benefits of working with diverse perspectives and personalities. So you can have complete confidence in those types of programs. Where the challenges have arisen are in things like critical race theory, where one race is sort of alleged to be a scapegoat for another's problem. So divisive concepts like that, you may want to stay away from, but DEI training in general remains a great tool in an employer's sort of arsenal of DEI. The next slide, we're going to talk about communication here very quickly. This is another thing where there's been a huge variety of approaches. Some companies don't choose to address issues like this, either publicly or in their workforce. It's kind of business as usual. We're just going to keep doing what we do. Others really want to be proactive or respond to concerns they anticipate in the workplace. And so it's hard to know what to do. You don't want to be seen as withdrawing from a commitment to diversity, but you don't want to be putting the organization forward with risk either. So you need to figure out where your organization stands, and then you need to decide if there are people you need to tell about it. Some companies are issuing a generalized message to their workforce, just reassuring them about DEI, telling them what diversity means to their organization, because it can be so many different things. There may be more targeted communications to groups like ERGs or diversity committees who have particular skin in the game when it comes to DEI. And then sometimes there are public statements or statements to boards, things like that, that just sort of clarify where a company stands and intends to be on DEI going forward. So there's a wide array of different communication methods there, but everything you put out there in the space, of course, becomes public and is subject to some sort of scrutiny or challenge, so be very careful with it. We're going to go ahead and provide the CLE code now, and then Annette's going to wrap us up. So you are able to just scan this QR code with your phone if you would like, and it'll take you to a registration process. You also had a link in your email today that confirmed the connection details. You can click on that. And the code for CLE is SS9411. 9411. Okay, so Annette, back to you.
Sounds great. Thank you so much. And we'll just wrap up here with a few takeaway points. The first is, it really is important to think about. On the next slide, you'll see we've been watching what the EEOC commissioners are saying quite closely, right? And others. But it is interesting to hear what they're saying. And if you really, kind of go through it, sometimes we're saying, oh, they have divergent views. But when you're really looking at it, they actually are aligned in many, many ways, right? When you have DEIB programs, what really is the purpose behind them, right? We are bound by Title VII, ADA, and a variety of other laws that require us to engage in non-discrimination. That's really the law of the land in Title VII in the U.S., right? Non-discrimination programs. So Commissioner Lucas recently talked about, right, as a general rule, race or sex can't even be a motivating factor, nor a plus factor, a tiebreaker, or a tipping point, right? That was her view in response to a statement that Mark Cuban put out there. Jocelyn Samuels, Vice Chair of EEOC, recently also made a comment. Reducing barriers in equal opportunity is not the same as unfairly putting the thumb on the scale. So when we look at it from a non-discrimination perspective, where do I have potential barriers for individuals to make it through our process? How do I address them? That is really what we're trying to do. And equal employment opportunities mean that we have practices that are there for everyone, right? So if we go to the next slide, let's just quickly look at some key steps. Really look at your workforce. Look at this from an inclusive perspective, inclusive culture that is effective and low risk. You want to consider all viewpoints as you're doing this. You can look at your data very specifically by business line, by business unit, and see where you have potential barriers, and not just focus on that, but understand, use the data to help drive to understand the why, not just the what. The what is the number that you might have, but why do you have that number? And how can you address that might involve looking at some of your programs, looking at your hiring practices, looking at your promotional opportunities, and how you go about doing that to ensure that you have a true culture of belonging and inclusive programming for everyone. And then the last slide, the last conclusion we'll say is nothing is as good or as bad as it seems. Christy shared, we get inundated almost every day. There's different reports that come in, cases that are being filed, challenges that are being made, and also very positive movement as well. So take a step back, look at your programs and your processes, do this audit that we're going to be talking about more in our next series, understand your DE&I programs, the specific initiatives, make tweaks if you have to, make adjustments where you need to, and recommit to the values of diversity and inclusion for everyone. We are certainly monitoring the areas of law. There might be changes that come and there may not, but we're going to continue monitoring and making sure that the programs and assisting employers, making sure that the programs that they're using are effective and inclusive for all. And with that, just a final reminder that our next series is going to be coming up on June 6th, and here are the rest of them that will be included. So we will be on the lookout for additional information be on the lookout for additional information about signing up from us, and we thank you so much. I know this is a half an hour and a lot of information is packed in, but the next series will focus more on specifically the audits and how you might provide that information. So thank you so much for joining us.